Case set with Mr. Woodward and Mr. Faulkner for sentencing, but I do not see Mr. Faulkner. So I know his client, Mr. Fortuno Borges, is here, and we will just see what happens as the morning proceeds.
Yes, Your Honor.
And Mr. Interlicchio is present. Mr. Escobar is present. Mr. Michaels is present. And Mr. Martin is present. Would you like Mr. Martin to sit with you at council table, gentlemen? Okay, we can arrange that. The court will come to order in case number 2012-5695, State of Florida versus Dante Martin. And Mr. Martin was found guilty by a jury of manslaughter, hazing resulting in death, and 2 counts of misdemeanor hazing in October, I believe. And we are here today for sentencing. The court has received the pre-sentence investigation, the defendant's sentencing memorandum, the correspondence from various individuals on behalf of Mr. Martin, the sentencing transcript, the transcript of sentencing of Mr. Baskin before Judge Lubit, and has read those things and is prepared now to proceed. Mr. Interlicchio is here for Mr. Ashton. And Mr. Interlicchio, do you wish to be heard on sentencing? I would like to see a score sheet.
Yes, Your Honor. If I may have a copy of the score sheet, and I'll provide a copy to counsel.
Wish to be heard?
Yes, Your Honor. The state would be asking for 9 years and 3 months in the Department of Corrections. That's what the criminal score sheet puts them out. It puts them up 9.31, so it's third is actually it's more like 9 years, 4 or 5 months.
And Mr. Escobar, are you going to handle this hearing, or is
Mr. Michael will be handling this.
Mr. Michaels?
Your Honor, good morning.
Good morning.
First of all, the issue of the score sheet I would like to address. We don't agree with the score sheet and the bottom of the guidelines. As the court recalls, we filed a pre-trial motion concerning the illegality of charging manslaughter and hazing. The court made a ruling on that, so for the purposes of the sentencing hearing, we would renew our objection in our motion to dismiss the manslaughter count.
And that motion is denied?
The second issue, Judge, is the issue of double jeopardy. The manslaughter charge and the hazing with death, it violates the fundamental principles of double jeopardy. In this case, we have the individual...
Counsel, I'm sorry, why on earth wasn't this raised in your sentencing memo? Why didn't you submit this to the court in advance? Did I miss something?
No, Judge.
Okay. All right. It certainly would have been preferable for the court to have been put on notice of this issue, for the court to have considered it. I like to do research myself and to perhaps research that issue. It seems if a significant legal issue is raised that the state is unwilling to stipulate to, it deserves full consideration, and all of these people who have traveled here for purposes of sentencing today deserve to have that done today. But with a significant legal issue hanging over us, I'm not sure that's going to happen.
Judge, frankly, it's a fundamental right that we didn't feel was necessary to raise ahead of time to the court. It's a right that in sentencing, if the court violates the principles of...
So I would just say in response to that characterization, if it is so fundamental, then why do the DCA spend so much time on it? I mean, it apparently is not second nature to many criminal felony judges. If it were, then the DCAs wouldn't have to waste so much ink on the issue of double jeopardy. So, go ahead.
Well, Judge, and I appreciate what the court is saying, but that's why there is a court of appeals to issues that there are significant questions about. This is an issue that...
I'm not sure you take my point, but go ahead.
This is an issue that can be raised for the first time on appeal. So I'm noting my objection, telling the court that we don't agree with the bottom of the guidelines, and those are the reasons for our objection. Okay,
if you'd like to argue further on the issue of double jeopardy, I invite you to do that.
Judge, I made my argument.
I beg your pardon?
I made my argument.
Okay, all right. If you have nothing further, then you may proceed as you deem appropriate.
Judge, what we're seeking is the court to consider a non-incarceratory sentence for Mr. Martin. And we base that on...
Well, if I could just go back for a moment. If the court agrees with you that it would be double jeopardy to sentence Mr. Martin on both manslaughter and hazing causing death, what does that do to the score sheet?
That puts it at 72.3 at the bottom of the guideline.
Okay. And you're asking the court to consider a non-incarcerative sentence, which would require the court to depart.
Depart downward, yes, Judge.
Okay, and how am I going to do that?
Well, the statutory mitigator, specifically that the victim was a willing participant in the act. In this case, we spent a week at the end of October hearing about what the process was about and how the individual had asked several times to do it. In fact, Keon Hollis said that he wanted to do this, that he was already a leader, that he could punish people in the band if he wanted to. He could mete out a physical punishment like push-ups and running. We heard a great deal about Robert Champion, his accomplishments in the band, being the very creme de la creme of the band. And we heard that Robert Champion asked his head drum major, Mr. Boyce, on several occasions during the year, telling him he wanted to cross, he wanted to cross, he wanted to cross. Jonathan Boyce testified that he finally relented at the end because it was the end of the season. So we certainly have somebody showing that they willingly participated in this event. Robert Champion was not, the state may have a position that it's peer pressure, but we didn't have anybody testify that anybody was pressured by anybody else to do this crossing of Bus C. We certainly were unable, unfortunately, to hear from Mr. Champion, but what we did hear from his fellow drum majors is that he wanted to do this. He asked on several occasions. And that evening, he went back to the hotel, went and changed, and came back to the bus. Nobody dragged him there, brought him there, or forced him there in any way. So there is no indicia of any sort of coercion on his part. We heard some testimony regarding respect. Well, the only way to get respect is then. But not one single witness could give us any bit of evidence, not one example of when they were disrespected because they had to cross bus C. So for those reasons, it is our position that the court may depart downward based on that particular issue, that he's a willing participant. I cited to the court a couple of cases. Certainly, there's no case that says in the Hazing case involving manslaughter or death that an individual who willingly participates in that hazing falls under that category.
Sure.
That the person accused of being involved in it get a downward departure. But there's some interesting cases when we talk about the illegal sexual conduct involving somebody underage who was unable to consent. I cited to the court a case from the Supreme Court regarding that. In that case, the girl was a 17-year-old girl. The courts agreed that the individual was able to consent, and therefore, even though it wasn't a defense, just like in hazing, that it was grounds for a downward departure. Interestingly enough, there was a case and that case is State versus Wright, 789 Southern 2nd, 288. Interestingly enough, there was another case kind of interpreting Wright, and that's out of the 2nd DC. I've invited that to the court as well. Holland versus State.
I didn't receive that in the package that you sent me. So when...
The site is in the...
Oh, the site.
Yes.
Okay.
I have a copy for the court.
Okay, if you'd like to hand me... That's fine.
That particular case is interesting that case involves a man and a 12-year-old boy. In that particular case, the defendant, Mr. Holland, approaches the court during sentencing and asks the court to consider a downward departure based on consent. The judge in that case said essentially, that's not a valid downward departure. District Court of Appeals said it may or may not be, but just because somebody's 12 doesn't mean that necessarily kicks them out of the ability to ask for a downward departure. So it's a question of fact. In this case, we have a 26-year-old man, not a 12-year-old boy. And we don't have sexual conduct. And we have other information that says that he wanted to do this. We have other information that says that he voluntarily did this. We have other information that says that he went to the bus by himself without anybody telling him. And we don't have any information that says that anybody approached Mr. Champion and said, if you don't do this, somehow somebody's going to think less of you. In fact, Mr. Holland said he looked up to Mr. Champion as being the top of the band, both in his musicianship, leadership, etc. So for those reasons, the court can depart downward in this particular case based on that statutory mitigator. Another mitigator, there's a catch-all phrase. The catch-all phrase that I cited in my memorandum to the court, the case involving, certainly what the law says is the court can depart downward for another reason as long as it's not prohibited in some way by statute or by case law. The case that I cited to the court stands for the proposition that in order to have parity in sentencing with co-defendants, the court may depart downward. So that is a valid departure reason. And that's Sanders versus State, 510 Southern 2nd, Supreme Court case from 1987. I don't know if the court got that one. Okay. And so that's another valid reason, because in this case, nobody, aside from Mr. Baskin, has received any kind of jail or prison time.
Well, Mr. Smith in Mr. Baskin's sentencing hearing went to great lengths to distinguish his client from your client, and in several instances said on the record, Dante Martin was the leader of this. He was the president of Bus C. I noticed that because I found it remarkable. So I would observe that at least one of the co-defendants argued that he was not as culpable as your client.
And I understand, and I saw that too, Judge, and I find it interesting because the argument by the state in this case is that Dante was the principal. Court, I'm sure remember Mr. Ashton, and quite effectively he argued to the jury that this man isn't the one that kicked or punched Mr. Champion that caused his death. The other people did, and that Mr. Martin was responsible for their blows. And that was his argument. And every blow is Mr. Martin's blow. So he obviously was looked at as a principal, and certainly that was the state's theory. And the court heard for a week how the meaning of the term bus president. He's not elected. He doesn't run for it. He's not chosen. It's kind of traditionally bestowed upon him because he's the oldest guy in the bus who did the crossing. And so Mr. Martin didn't have the power to summon Mr. Champion there. We heard testimony from Mr. Turner that that you could go through the bus even without the bus president being there. Yes, Dante Martin was present. Yes, the jury found guilty as a principal. But to say that Martin is more culpable than he is delivering the blows and kicks, I think is not reasonable. I think it's more reasonable that as a principal and as not having delivered any of those blows, because he's the president in name only, does not make him more responsible or more culpable than Mr. Baskin. In that same...
That may not have been how Judge Lewin saw it.
Well, we don't know. And in that same sentencing transcript, Mr. Ashton brought out the fact that individuals observed Mr. Baskin kicking Mr. Champion. So I don't think that there's any question that bus president was something other than just a symbolic title. The other issue is you have all the other co-defendants, none of which received prison. Somebody had to be punching and kicking Robert Champion, and we know it wasn't Mr. Martin. So if those other individuals are allowed probation, then in order to put Mr. Martin in parity with their sentences, the court may depart downward.
Yes, sir.
There's another issue too, Judge, that frankly I just thought of on the way driving over here. And it also fits into that catch-all. In this particular case, we had testimony from Dr. Irving essentially that if the proper precautions were taken when EMT answered the call at the bus, they put a pressure suit on him, Robert Champion's life may have been saved. If EMT was promptly called and EMT was informed about what happened, he may have been saved. Based on that testimony, the state asked for that instruction as part of manslaughter, where that is not defensive manslaughter. So I would take the position that that's in the catch-all phrase too, whereby even though that is not a defense to manslaughter, that it's kind of in the same area as the consent issue in that it's not a defense, but it's grounds for the court to downward depart and falls under that catch-all phrase.
Anything else?
In terms of legal reasons of departure, Judge?
Yes.
No, ma'am.
Do you have testimony that you wish to put on in this case?
I do, Judge.
And that testimony goes to what?
Goes to the character of Mr. Martin.
And that's relevant to?
That's relevant to the court's ability to justly sentence the individual.
If the court determines there is a legal basis for departing downward, the question is, should the court downward depart? And so that testimony would go to that issue?
That testimony would go to that issue in terms of the court, because I don't have the inform you. In the sentencing, what the court looks at is, first of all, whether or not something is a legal sentence. So no, Judge, their testimony would not go to whether or not the court may downward depart or not. The court heard testimony for a week, and certainly I put forth the legal reasons for downward departure, so their testimony would not have to do with that, but instead would have to do with the other part of sentencing. Once the court determines whether...
I thought that's what I just said.
Okay,
should
Judge?
The court depart.
Okay.
How many witnesses do you have?
13.
You have submitted a number of letters from individuals on behalf of Mr. Martin. Surely you're not going to call the individuals who wrote the letters?
Some may, yes, Judge. Some travel from Tallahassee.
I don't care whether.
Texas.
I don't care if they wrote letters and the state has no objection to me considering those letters. Why do I have to hear redundant testimony?
It won't be redundant. There are other things that they will add.
All right, thank you. Mr. Interlicchio, do you wish to be heard on the issues raised by counsel?
Yes, Your Honor. I'll start with the double jeopardy issue. I mean, let's just say even if the defense claims it's double jeopardy, which the state's not conceding and does not agree with, the math that they did, I'm not sure how they came up with it, because there's only one count that would be double jeopardy, which would be the college hazing causing injury or death, which is an F3 felony, which would remove 0.7 points away from the score sheet, which would affect the score sheet by basically next to nothing, just a couple of days. We're not asking you to sentence him to the bottom of the guidelines. We're asking you on count 1, which is the only one that allows for beyond 5 years, to sentence him to 9 years, 4 months in the Department of Corrections. So that issue, I'm not sure where they came up with that one. As far as being a willing participant, defense counsel cites to Wright v. State. And Wright v. State stands for a 17-year-old girl who has a relationship with a man who's over 18. The court factored in that these people were in love, that they were living together, that were caring for each other. They were all agreeing they were going to get married later. This is all about taking that into consideration and allowing the court to take the totality of the circumstances into consideration when making an appropriate determination of downward departure. That's what Wright stands for. Holland stands for the premise that the court can't keep saying, hey, I'm bound, I don't have any room to depart. Holland says, no, you have the room to downward depart if you see the factors there. And in this case, he's not a willing participant in his own death.
Well, let's talk about the facts of the Holland case, which are significantly different from the Rife case.
Yes.
Because Judge Altenburn says in Holland that the trial court erred when it found, without further consideration, that a 12-year-old was incapable of consent, that wasn't the proper analysis, that the analysis was willing participant, and that a 12-year-old could be a willing participant in the crime alleged, and sent the case back for a resentencing hearing.
Yes.
So those facts are significantly different from Rife, where it was, as you have characterized. And so if it is conceivable under the law that a 12-year-old child could be a willing participant in a lewd act or sexual battery case. How is that different from a 20-some-year-old man being a willing participant in an established and ongoing tradition of this particular type of hazing? How is that different?
Well, first and foremost, sex in and of itself is not a crime. It's only a crime because of the ages of the party.
Okay.
So you have someone...
That seems like hair splitting to me. Sex under the circumstances, sex under any circumstances with a 12-year-old is a crime.
Exactly, but the ultimate act itself that the child achieved is not the crime. Here...
Sex under any circumstances that the child... I don't understand that.
Okay. With regards... Sex of the child is not really important here. What's important here is...
No, it didn't occur in this case.
Exactly. We're talking about, first of all, manslaughter. There's no way you are, in this case, based on the facts, he was a willing participant in his own death, that he intended for his own death.
Let's look at what does the statute say. The statute says the victim was, ellipsis, a willing participant of the incident. Of the incident. So it doesn't say... a reasonable interpretation of that language is the incident was this tradition of hazing on the crossing of Bus C. I would read this as the court could depart if it finds that Mr. Champion was a willing participant in the crossing of Bus C. How would you read it?
I disagree with the interpretation, Your Honor. I think it's the child, just like it's saying, a willing participant in the act. So he was
in the incident. What does the incident mean?
In this case, I would say the incident would be not his death. That's the thing. It's the ultimate act that's being achieved. So, like the sex act, the child was a willing participant to have sex. In this case, he is not a willing participant in the ultimate crime, which is his death. And I don't even believe that there's any facts that say he really was a willing participant.
Okay, I don't want to get to that yet. That seems strange to me, that there could be, under the law, as Judge Altenburg says, there is the possibility that a 12-year-old child could be an instigator, a willing participant in a sexual battery on a 12-year-old child. But a person could not be a willing participant in an incident leading to his death. That's what you're saying?
Yes.
Well, of course, there's no case law that says that, but I'm just not following your analysis in that regard. How is that different?
Because the child is ultimately agreeing to the final, what's the end line? The finish line of what the child agrees to is sex, right? So he's agreed to get to the finish line, which is sex. This person did not agree to die. He made there's nothing that he said, I'm going to do something that's going to get me killed. He never agrees to this.
Okay, I get it. Okay. I don't know what the legislature means. It does say the incident. So, the incident.
Now, as far as being a willing participant, yes, he was a member of the band, but it was also, what weighs into it is the coercion factor. This is somebody who waited to the very end to get involved in this. There was talk during the case discussing how, as a leader of the band, the only way to get the respect of the other band members, to get the people to do what they're supposed to do, is you have to do this awful thing where you run a gauntlet down the bus and you are blindly and savagely beaten. And that's the only way to earn the respect of the other members of this bus. And it's the only way that the people will agree to do things. That's the only way he can get the other members of this band, to do what he needs them to do as he becomes the leader. That's it. That's not a willing participant. That is coercion. That is
This is unfortunately 50 years of allowing a university's band to run wild, allow these kind of activities to take place, and this kind of savage mentality to be the status quo. That's unacceptable, and if he's stuck in this environment, that cannot possibly mean you're a willing participant in it. I mean, he is just basically a victim of the circumstances that have been allowed to flourish there. So to argue to say that he really wanted to go down the bus and he was excited about his opportunity to get his teeth kicked in and die is just ridiculous. The next issue defense brought up is parity in sentencing. As far as Baskin is concerned, we're appealing Judge Lubitz's ruling. The court is well aware of that. Secondly,
yes, we don't know the status of.
No, unfortunately, we don't.
Would have been nice.
Yeah, would have been helpful. However, when it comes to defense, keeps bringing up something. He is the president of Bus C. Okay, and I don't care how he got it, this de facto thing, but he was the president. He was the commander-in-chief of this bus. And things didn't happen on this bus without him getting involved. There was talk about the hot seat, and he chose who got to go in the hot seat. So he placed somebody in the hot seat on the bus. Those people were selected by him. Now, he does not, and as Mr. Ashton pointed out during the trial, he does not land the blows, but he directs the other members of the band to put the blanket or the towel on them, to beat them. He's the one who says, stop. His role when prepping them to run through the gauntlet, he's the one who selects them and tells them, it's your turn. Stand up there, hold on to the rails. They're just getting slapped back and forth. And then he's the one who says, go. He is more. As a leader, as a man, it takes responsibility and it takes actions to make the right decisions. And as the leader, he could have said, we're going too far. This can't happen. But no, he reveled in it. This is someone who practiced it. He ran his bus. He ran a tight ship. And he sent a lot of people down that line. And he is directly responsible, blow for blow, of everyone on that bus. It's just like anything else. It's the commander-in-chief of an army. It's a sergeant of a police department. He's responsible for everything that happens under his direction and purview. Not once did he try to stop it. And in fact, he encouraged it, and he allowed it to go on. So my argument is he's far more culpable. I'm not even really going to delve into blaming first responders for not rendering the care that they believe theoretically might have been able to save his life. That's neither here nor there. But the state, as previously stated, based upon his actions, based upon his role as leader in this organization, based upon him allowing this activity to go on, facilitating it in every way, shape, or form, he deserves every bit of 9 years and 4 months.
Counsel, I'm not persuaded by the argument pertaining to the first responders, but if you would otherwise like to speak to Mr. Interlicchio's arguments, do so.
It's important to note that in this particular case, in terms of being a willing participant, the only reason why this is illegal is because the hazing statute says that consent is not a defense. Otherwise, an individual who undertakes a dangerous undertaking or some kind of challenge, and I know we talked a little bit during the trial or tried to talk about running of the bulls and all that. I mean, being the president is no different than the guy who takes the ticket of these people who want to run down the line and get chased by a bunch of bulls. So that's what the bus president is. He doesn't choose anybody. They go there to participate in his tradition. We heard the whole week about what this tradition is about, and that's important here. I mean, Dante Martin got charged as the bus president. Florida A&M president should have been sitting at a defense table somewhere charged. Those band directors should have been sitting at a defense table charged. Because what we heard of is that these impressionable young people are sent by their parents to a university and are taken by that university and are essentially bathed in this tradition and given the burden of carrying on this tradition. The court heard that these kids know what was going on that bus and on the campus when they were in high school. And so to suggest that that this is somehow being done behind the back of the university, it's beyond absurd.
Well, that's getting a little far afield from the issue of willing participant.
Judge, in terms of the incident, by participating in this event, which a jury has found to be hazing, the individual participating in it, Mr. Champion, Lissette, Sanchez, and Mr. Hollis, they're all guilty of hazing as well under the statute. So it's a little different in an innocent person in terms of a 12-year-old boy consenting to sex with a grown man. This issue is even stronger in that the participant in the incident is also breaking the law.
Well, not if the incident is manslaughter. But, as you say, it is so subsumed in the hazing that that's splitting some pretty fine hairs, I think.
Judge, not only that, but the manslaughter, yes, he is not consenting to manslaughter, but manslaughter makes it manslaughter only because it's not a legal act. If it was a legal act, then it's a misfortune that happens during the legal act, and therefore it is a defense to manslaughter.
And manslaughter, I'm not sure, is the incident. Okay.
So, I mean, however, whatever the analysis is, before it can be determined manslaughter, it has to be hazing first. Otherwise, we don't get that far. So the incident, it has to be hazing.
All right, counsel, would you like to call your witnesses now?
If I may, Judge.
Go ahead. And brevity would be appreciated.
Where do you want them?
I think so, in the box.
Dr. Gertz?
I do.
Please state your name.
Mark Gertz.
And how are you employed?
I'm a professor at Florida State University in the College of Criminology.
And how long have you been so employed?
I'm in my 39th year.
And are you, in terms of that program, the criminology program, how is it ranked in the United States?
It just so happened to be the number one program in the country.
And are you a published author?
Yes, sir, I am.
Okay, in what field?
Criminology, I have a number of areas of expertise, but I published 3-4 books, 50, 60 articles, so I publish quite a bit.
And even though you're not testifying as an expert here, have you been qualified as an expert in state court?
Federal court and state court as an expert in research methods.
And did you have occasion to work on similar issues in terms of hazing and those sort of things for Florida State University?
Similar issues, yes.
Okay. And were you a chair of a committee?
Right. I was asked to chair a committee a number of years ago at Florida State.
And let me ask you, what is it that you can tell the court to aid the court in rendering a fair sentence in terms of Dante Martin?
I feel uncomfortable telling the court anything about how to do its job. But in my world, first of all, there's a name for what happened in this case. It's called victim-precipitated homicide, where the victim participates in their own case. But for me, in what I've studied, I was chair of a committee at FSU many years ago where the amount of alcohol being consumed during rush at fraternities was staggering, and all kinds of people were having toxic poisoning, all kinds of problems. So I was asked to chair the committee, and the function of the committee in the end was to eliminate alcohol from rush, which we did. Nobody thought for a second that we were eliminating all the problems of the university or all the problems that alcohol causes, but we did eliminate alcohol from rush. And it seemed to me the parallel in this case was when the adults took over, the problem got solved. This was a disaster. To me, actually, the only surprising thing about this is why didn't it happen before? I can't understand it. But this was something so well known in the community, so widely known. I mean, virtually nobody didn't know about this kind of behavior. And at FSU, at least in this one instance, the adults took over and put a stop to a behavior I don't understand. I agree with the state's attorney who said that the university itself, I mean, it seems to me somebody from that university should be taking responsibility for allowing this to happen. Again, it's not as if they didn't know that this was happening.
And how long have you known Dante Martin?
I don't know, 4 or 5 years.
And how do you know him?
He works. He's the main guy at the best restaurant in Tallahassee, and we go there a lot. And like everybody else, we always ask for Dante to be the person to wait on. And honestly, he became sort of a member of our family, very close with my younger daughter, and so he's somebody that we've always felt really, really connected to. And I know this isn't germane at the moment, but I think he's a wonderful young man.
Tell the court what sort of relationship he had with your family and your daughter.
Well, with my daughter, I think my wife would be better at this than I would, but he was really a mentor. My daughter was a major in hospitality management, and Dante was tremendously helpful in mentoring her and showing her the ropes, and he treated her very nice. She worked at the restaurant, and they became personal friends, but he also, we were more impressed with his mentoring and how he helped her, and she's now has a very successful career. She's in Philadelphia doing very, very well, and she herself would attribute a bunch of that credit to Dante.
And is there anything else you wish the court to know about Mr. Martin?
No, I don't know.
Thank you.
Cross-examine?
None, Your Honor.
Thank you. Call your next witness.
Professor Sally Gertz.
I do.
Please state your name.
Sally Gertz.
How are you employed?
I'm a professor at the FSU College of Law.
And so you traveled here from Tallahassee today?
Yes.
Dr. Gertz is your husband, is that right?
Yes.
And what do you teach at the University of Law?
I practiced labor and employment law for employees for 12 years. Then I was a labor and employment law judge on the Public Employees Relations Commission. Since I've gotten to the law school, I started by teaching labor and employment law. Now I supervise law students doing internships in their second and third year.
And how do you know Dante Martin?
The restaurant where Dante was the head waiter is a block from our house, and we go there at least once or twice a week. We go there doesn't quite describe that we hang out there. We know everyone. We know the waiters. We know the chef. We spend a lot of time there. And Dante was the head waiter, so we got to know him. I, having represented employees my whole life, love to watch employees, especially great employees, and he is great at his job. You know, it's fun to watch someone so energetic, so focused, so willing to take responsibility and to take care of everyone and to know what's going on and to be really quiet and dignified while you're doing it and not drawing attention to yourself. He's just a really capable young man.
And he knows your daughter, your husband.
My daughter was a hospitality major and wanted to learn the business, so she was hired as a waitress. As a mother, I can tell you, having a cute young single 18-year-old daughter as a waitress caused me some anxiety because sometimes the industry is not kind to young women. And I could not have wished for a better boss. Dante was her boss. He trained her. He took her under his wing. He treats what's remarkable about Dante is that he treats everyone with great respect. So the governor is in that restaurant all the time, and Dante treats the governor the same way he treats the dishwasher. I mean, he is really everyone with great kindness.
Now, should the court sentence Dante Martin to prison, there's an issue that's coming up regarding potentially an appellate bond. You're aware of what that is, correct?
Yes.
Based on what you know in your interactions with Dante, do you feel that he's a risk of flight now?
Absolutely not. Dante is a very upstanding, law-abiding. He believes in rules. He believes in people behaving appropriately. That would be no risk at all.
And do you feel that he would satisfy the obligations placed upon him by the court in that sort of scenario?
Yes, absolutely. I trust him absolutely. I would trust him to obey any rules or laws that he was asked to obey.
Is there anything you want to tell the court aside from what we spoke about regarding Dante and the sentencing?
This is a young man who has a lot to contribute in the future, and I hope that this will not end his ability to be a really valuable, contributing member of society.
Thank you, Your Honor.
Cross.
No, sorry.
No, Your Honor.
Thank you.
Kevin Stout.
I do.
Please state your name.
Kevin Patrick Stout.
And how are you employed?
I'm the chef and part owner of the restaurant that Dante used to manage.
And what's the name of that restaurant?
Food Glorious Food.
And where is it located?
It's in Tallahassee, Florida.
And you drove down from Tallahassee today?
I did.
And how long have you known Dante?
4 or 5 years, a while.
And what sort of duties has he had at the restaurant?
Well, Dante started out, everybody starts out at a host position. You start at the bottom and work yourself up. Dante was able to do that quickly. He's one of the hardest working gentlemen I've ever had work for me, one of the smartest guys, also one of the most gentle guys. Very good at his job. We have a lot of customers that come in, still ask about Dante. As Ms. Skirts said, and we have the governor that comes in there, we get a lot of FSU professors and sports people and people come, legislators that come in there, and he's always requested.
And what sort of, Dante's a manager of sorts now, is that correct?
Yes, sir.
And what sort of management style is he with? Is he yelling people? Tell me what.
Well, one of my biggest things is part of our job is being a teacher. It doesn't do good when you just scream at people. I've worked for people that were screamers. I'm an ex-Navy guy. I've been screamed at plenty of times. And I think part of the job for my managers is to teach these people. And Dante has understood that and has always done a very good job at that.
And so in terms of what you've observed, is he effective in teaching others?
Absolutely. That's why we're one of the best restaurants. And we have the awards to prove it in the state.
And what sort of awards?
Several consecutive Golden Spoon Awards, top restaurants in 200. I've been able to achieve some accolades from my career as the chef, so we're doing very well.
And is there anything that we haven't spoken about that you wish to tell the court about?
Well, Dante has become a part of my family. Just the same thing Sally Gerd said. My children know him. I have a 10-year-old and a 12-year-old. When the verdict came down, we were watching the news, and, my children started crying. My wife started crying. I feel emotional right now. He means an awful lot to me and my family and to my business as well.
If Dante Martin were to be given some sort of a non-jail or prison sentence, would he still have a job there?
Tonight.
And in terms of what you know about his character, that issue about should the judge sentence him to prison or jail, there's an issue of whether the court would allow him to get out while an appeal is pending. Based on what you know, is Dante the type that would flee?
Not at all. You know, all through this process, obviously it's gone on for several years. I've actually had a lot of FAMU band members work for me also. He stood by the system. He believed in the system. He knew the system was going to work for him, not against him. I absolutely would not flee.
I don't have anything else.
Cross?
None, Your Honor.
Thank you.
Susan Turner? Please state your name.
Susan Turner.
And you're one of the owners of Food Glorious Food.
I started Food Glorious Food in 1982.
And what sort of a restaurant is it?
It's a casual fine dining restaurant in Tallahassee.
You know Dante Martin?
I know him very well.
How long have you known him?
I believe Dante started working for us in 2010, and so I've known him since then.
And I'll ask you the same question that I asked Mr. Stout. Does he still have a job?
Absolutely, right now.
What do you want the court to know about Mr. Martin?
When you own a business, you think about what the perfect employee would be, and that's Dante.
Why is he perfect?
He nurtured everyone that was under his care, be it a customer, be it wait staff, be it the dishwasher, whoever was there. He always treated everyone with kindness, fairness, a sense of humor, graciousness. He was so responsible, very, very dependable, honest. I mean, he was in charge of locking up the restaurant at night, handling money. There was never a moment of doubt that Dante did not handle everything with the highest, just the highest level of quality.
And let me ask you the same question that I've asked some of the other witnesses. If he were to be sentenced to prison or jail, and during the pending appeal, if the court were to allow him to be bonded out, do you have any doubt that he would appear before court as necessary?
No doubt.
Do you think he's a risk of flight?
Not a bit.
Do you have anything else you want to tell the court about this?
He's one of the finest human beings I've ever known, and it would be a waste if he were not a productive member of society.
I don't have anything else. Thank you.
Cross?
None, Your Honor.
Thank you.
Stephen Turner.
Before you sit down, please raise your right hand. Please.
Yes, ma'am. Okay, thank you.
Please state your name.
Stephen Turner, Turdr.
And you're an attorney, correct?
I am. Yes, sir.
What firm are you with?
Broad Gazelle.
And what is your position there?
I've been the managing partner of the North Florida, Tallahassee area for, I think this is my 28th year.
And so you're located up in Tallahassee?
I'm from Tallahassee.
And you drove down here with your wife?
I was born in Tallahassee.
Okay.
Not too many people are born in Tallahassee.
Excuse me? I didn't hear you.
I said not too many people are born and live there, stay there. So I'm one of the ones that were born and have stayed there.
Now, do you know Dante Martin?
I do.
And how do you know him?
Through the restaurant.
And what do you want the court to know about Mr. Martin?
Well, I think everything that the witnesses preceding me have said, I would subscribe to 100%. I think sometimes we let me back up. I've done some criminal work. I was a JAG officer in my earlier years before I went into private practice. And I've done some criminal work with various partners of mine over the years before I became affiliated with Broad Purcell. And I think I have a good feel for the criminal issues because of that experience. This man may be, and the court has to determine that, guilty of crime, of a strict liability type crime. But he is not a criminal, in my mind. He is a very honorable and decent human being, and the system needs to be selective enough that we understand the difference in people that we're dealing with. And I just can't fathom the injustice of this man being in jail. He is not a criminal in the sense that we would use that word loosely. He is not a violent person. He is not a dangerous person. He is not harmful to people. He is not dishonest. He is everything that we want. We want people in the minority communities to excel, and we don't want to repress those that are excelling. I just would encourage the court to do everything you can, Your Honor, to consider that this is a very exceptional individual and a very honorable individual. And if there's any way we can put him back into society and be useful and be a member that can guide others in the right way, he's going to do it.
So do you think that Mr. Martin would be effective in counseling others not to get involved in hazing and that sort of thing?
I just think he's a natural leader with people because he's kind, he's understanding, he's tolerant, and he's honorable. What I use the word honorable is someone I can trust. I mean, I don't have any problem trusting people that are if he tells me he's going to do something, I know he will do it. He's taken care of us for years. We didn't have anybody but him wait on us in the restaurant. And I got to know him quite well over the years just talking about things. So I can't say enough good about this young man in the community. It's been a while since I've done criminal work, but this is not a criminal. That's my point. This is a very fine young man, and the system needs to respect that, I think.
Let me address the issue of appellate bond with you. Based on your knowledge of Mr. Martin and his character, do you feel that he's a risk of flight? No, I think he should be given every opportunity to work and be gainfully employed and help while he's on bail. And whatever the issues are in this case need to be aired. It's a difficult case. I can see the court struggling with it. And I think these issues need to be aired out, and the court give Mr. Martin a chance to allow that to happen without any total punitive action in the interim. I don't have anything else. Thank you.
Thank you.
Thank you, sir. Thank you, ma'am.
You have no cross.
No.
Thank you. Call your next witness.
Latoya Divers.